ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. सभी को नमस्ते, जय जोहार. Good morning everybody and welcome to this event on the Forest Rights Act and ATREE's engagement with the Forest Rights Act. This is a very special occasion for us because across 3 states, Karnataka, Chhattisgarh and Madhya Pradesh, the work that we are doing at the grassroots, जो हम जमीनी स्तर पे काम कर रहे हैं, इस वहाँ के जो लोग जुड़े हुए हैं उन्हीं को हम साथ में यहाँ ले आए हैं. ಇಲ್ಲಿ ಕರ್ನಾಟಕದಲ್ಲಿ ಬಿಳಿಗಿರಿ ರಂಗನ ಬೆಟ್ಟದಲ್ಲಿ ನಾವು ಮೊದಲಿಂದಲೇ 25 ವರ್ಷಗಳಿಂದ ಏಟ್ರಿಯಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಾ ಇದೆ. ಆ ಕೆಲಸದಲ್ಲಿ 2008ನೇ ಇಸ್ವಿಯಲ್ಲಿ ಅಲ್ಲಿ ವನ ಹಕ್ಕುಗಳ ಬಗ್ಗೆ ಕೆಲಸ ಶುರು ಆಯಿತು. ಸೊ ಇನ್ ಸಮ್ ವೇಸ್ ATREE is a pioneer in starting work on Forest Rights Act in the field, especially in Karnataka, while also doing research and policy-oriented work in this subject. I think for many of us, the Forest Rights Act is something that we know, we hear about. And in ATREE, certainly, there is a lot of sympathy, at least, towards the Forest Rights Act, but not necessarily that we all know the nuances and the details, and particularly the history behind the emergence of this act and what the act is exactly trying to do. So I'm going to spend the first 10 minutes talking a little bit about the Forest Rights Act, although this might be repetition, certainly for some of you. The Forest Rights Act is based on 2 foundational principles. One is historical injustice and redressing historical injustice, and the second is deepening democratic rights. ऐतिहासिक अन्याय और लोकतंत्र की पद्धति से जंगलों पर जंगलों का प्रबंधन करना, ಕಾಡಿನ ಆಡಳಿತ ಜನ ಸಹಭಾಗಿತ್ವದಿಂದ ಪ್ರಜಾಪ್ರಭುತ್ವದ ಒಂದು ಪ್ರಿನ್ಸಿಪಲ್ ಇಂದ ಅದು ನಡಿಬೇಕು ಅಂತ ಅದರಲ್ಲಿ ಒಂದು ವಿಚಾರ ಇದೆ. ಆಮೇಲೆ ಐತಿಹಾಸಿಕ ಅನ್ಯಾಯ ಯಾವ ಆಗಿದೆ, ಕಾಡಿನಲ್ಲಿ ವಾಸ ಮಾಡುವ ಜನರ ಮೇಲೆ ಯಾವ ರೀತಿ ಅನ್ಯಾಯ ಆಗಿದೆ, ಆ ಅನ್ಯಾಯವನ್ನು ಸರಿಪಡಿಸಲಿಕ್ಕೆ ಮತ್ತೆ ಪ್ರಜಾಪ್ರಭುತ್ವದಲ್ಲಿ ಈ ಕಾಡವನ್ನು ಯಾವ ರೀತಿ ನಾವು ಆಡಳಿತ ಮುನ್ನಡೆಸಬಹುದು ಅಂತ ಒಂದು ವಿಚಾರದಲ್ಲಿ ಈ ಕಾನೂನು ಬಂದಿದೆ. But it's important to understand the background to these ideas, especially the idea of historical injustice. So I'm going to just give you 2 examples. And the first is from BRL itself. And if you dig up the reserve forest notification for Dodsampike Reserve Forest, which was notified in 1891, and you read how they have recognized the presence of local communities and their rights, which is required as per the 1878 Indian Forest Act itself. So you will see that they mention the presence of Soliga communities in different podus. For example, this is what today is known as Nellikadru. In favor of jungle tribes of Nellikadru, the following are excluded from reservation. And what is exactly being recognized and excluded from reservation? Their village site, 1 acre, their burial ground, 1/4 of an acre, their shrine, 400 square yards in extent, and they are also allowed the use of water from a pool located at such and such a place. End of story. So people are supposed to live in huts, people are supposed to bury their dead, people are supposed to drink water from a pool, and people are supposed to pray. ಅಂದ್ರೆ ವಾಸ ಮಾಡಬಹುದು, ಪೂಜೆ ಮಾಡಬಹುದು, ಜನ ಸತ್ತೋದ್ಮೇಲೆ ಅವರನ್ನು ಅಲ್ಲಿ ಮಣ್ಣು ಮಾಡಬಹುದು, ನೀರು ತಗೊಳ್ಬಹುದು, ಇಷ್ಟೇ. These are the only rights that have been recognized. इसमें और कुछ अधिकार यहाँ पे दिया नहीं, सिर्फ रहने का, मरने का और पानी पीने का, पूजा करने का. So this is an example of the way in which the colonial government completely ignored the presence of tribal communities or forest dwelling communities, except to say that yes, they exist so they can live on water and air. No hunting rights, no fishing rights, no forest product collection rights, no obviously cultivation rights, and so on and so forth. The second example is from central India. So this is the Central Provinces and Birar Forest Manual. published by the British in the 1900s itself. They have a chapter on forest villages. And they say it is of great importance to secure a permanent supply of labor in the forest reserves and to provide employment, because these forest tribes have been debarred from supporting themselves by dhya cultivation. Dhya cultivation is actually shifting cultivation. So across central India, in the forested, in the Adivasi area, shifting cultivation was the primary form of cultivation by the Adivasi communities, a whole range of such communities. And the first thing that the British did when they took over the forest was to ban shifting cultivation. And they recognized that by banning shifting cultivation, the livelihood is actually destroyed. And so they want to use this labor that is now essentially sitting idle, as per their perspective, for work in the forest, which was of felling trees and transporting them, making roads in order to enable the transport, and so on and so forth. So forest villages are designed solely to afford a permanent supply of suitable local labor, and very clearly only persons who are by race, caste, or occupation habituated to the extraction or handling of forest produce shall be admitted to reside in a forest village. And then they name some of the communities: Korkus, Gonds, Baigas, and so on. So these are just two extreme examples of the kind of historical injustice that was piled on to the forest-dwelling communities of India by British actions, and unfortunately continued post-independence for a very long time. The banning of shifting cultivation, even in the case of settled cultivation, often not recognizing settled cultivation because a lot of forest boundaries were drawn fairly hastily, and people living inside those forests were not even mentioned in those notifications. Limiting forest access and imposing a state monopoly on the sale of forest products. Whatever is valuable in the forest is owned by the state and will be sold by the state, extracted by the state. Of course, not only limiting access, but then completely denying the right to manage the forest as per the needs of the local community. A special example or special case is that of the forest villages, where you're creating not just communities in an enclosure, but a bonded labor kind of community, because in the forest village rules, each household is required to supply one person for labor in the forest in return for being allowed to cultivate within that enclosure. So it was a quid pro quo, as in the sort of majesty of having given them the rights for cultivation within a very small area. They were supposed to provide labor. And post-independence, when the Wildlife Protection Act came in 1972, since anyway these people's existence was not recognized in the law, they were treated as encroachers and evicted now in the name of wildlife conservation. And similarly, in the case of diversions under the so-called Forest Conservation Act, when they were building dams, when there's mining involved and so on, again, the presence of local community is not recognized. And therefore, when the diversion happens, the fact that their livelihoods are being destroyed is nowhere in the picture in taking those decisions. They have no voice in either the evictions for wildlife conservation or evictions or diversion of forest for mining and dams. So this is the kind of historical injustice. These are the different layers or nuances of historical injustice that is involved, that is behind the passing of the Forest Rights Act. And the Forest Rights Act, which was passed in 2006 and came into effect in 2008 after the rules were notified, seeks to address some, not necessarily all of these historical injustices. And of course, it does not do them perfectly, because the conditions across the whole country vary quite a bit. Nevertheless, I think it does a pretty heroic job of trying to redress these injustices. It starts by talking about individual rights to continue prior cultivation or prior habitations that are on so-called forest land. And why I say so-called forest land is because land that has been incorrectly notified as forest land when actually there is cultivation happening in that place. So the individual rights are about continuing the prior living and cultivation, strengthening the rights of access to forest produce and to access the forest for religious and other purposes as per their traditions. So these are called community rights or CRs. And I'm mentioning the acronyms because many people in the presentations that follow will use these acronyms, because that's what they are quite comfortable with them. And most important, perhaps, the right to manage traditional areas, what are called community forests, within their traditional boundary. And this we call CFR. In Chhattisgarh, they call it CFRR. This is the combination of redressing the historical injustice, which was the loss of management rights, combined with the idea of democratizing forest governance, because it imposes a requirement on the rights holders to democratically manage the forest. They cannot follow their traditional method of one person deciding or 5 people deciding on behalf of the village. They have to elect a forest management committee, and the committee is answerable to the Gram Sabha, that is the adult population of the village, and must operate through the Gram Sabha. So this is an attempt to also democratize the functioning from the bottom up. There are additional rights in the FRA to convert forest villages to revenue villages. And the idea of habitat rights was introduced for particularly vulnerable tribal groups who are still practicing, in many cases, shifting cultivation. And the idea was that at least in the habitat rights section, the rights that would be given would include the right to continue shifting cultivation. That was the idea behind habitat rights, that they would have a very large area set aside for that particular community in which they would continue their traditional practices, including shifting cultivation. Unfortunately, wherever in the country habitat rights have been recognized, nothing of that kind has happened. That's a different story, but that was the thinking perhaps behind the habitat rights. And by the passing of the Forest Rights Act, it gives them a say in both the declaration of a protected area or the standard eviction procedures that get initiated when a protected area is formed. It gives them a say in that process, and also a say in the forest diversion process. That is in the Forest Conservation Act and the processes under the Forest Conservation Act. So this is how the FRA tries to redress these historic injustices and introduce the idea of democratic decentralization starting from below. Now, coming to ATREE's journey with the Forest Rights Act, I think ATREE has been one of the research institutes in the country, perhaps the only research institute that has engaged not only consistently, but right from the beginning, perhaps before the Forest Rights Act itself was passed, with the idea of using the Forest Rights Act or seeing the Forest Rights Act as a way of democratizing forest governance, as a way of strengthening the role of local communities in the management of forests as a right, not just as a tool for participatory management as and when the forest department finds it convenient. We've engaged with the Forest Rights Act in a variety of ways. Of course, we have done a lot of conventional sort of applied research, we might call it, and I'm just going to give you some glimpses of that. We have done a lot of research on NTFP ecology and economics. Those of you who are from ATREE here would have heard the NTFP ecology research in BR Hills and surrounding areas over the last 25 years. So I don't need to repeat the work that has been done on amla or nellikai, on honey, on shikekai, and so on and so forth. A huge amount of work has been done on the ecology of non-timber forest products. There's been work done on NTFP livelihoods in BR Hills also. But in the last few years, there's also been work that has been done in central India, in Maharashtra, in Madhya Pradesh, on the question of how non-timber forest products respond to harvesting. What are the methods that people use, and what are the debates about the methods that are happening, for example, in the case of tendu leaves, a very important non-timber forest product in central India. And what are the ways in which villagers are changing the marketing of tendu leaves, for instance, once they have gotten rights under the Forest Rights Act. A recent study looked at the entire impact of villages receiving community forest rights in eastern Maharashtra on people's livelihoods, on the forest itself, and on the process of empowerment, in the sense that what is visualized in the act as a democratic process building up in the village for the management of the forest. To what extent have these villages, which have been doing community forest management since 2015 or so, what has been the progress towards the goals that are envisaged in the act? So this study has recently been completed. So we've done a lot of this kind of, welcome Rohini. We have certainly completed a fair amount of this kind of conventional applied research, both ecological, socioeconomic, sociological, on the question of how the Act operates, how it is being implemented, what are the implications of the Act on the ground. Obviously, the thinking behind conventional applied research is that we will speak truth to power. We will produce the knowledge and we will spread it wide in the public as well as to policymakers. And we will assume that policymakers will listen and actually change or improve or fine-tune the policy, whether it is with respect to implementation of the Act or the supporting policies required afterwards. Similarly, in some cases, we have managed to give direct inputs into policy making and implementation of the Forest Rights Act. And again, I think ATREE's work in Karnataka is less well known because it was done through channels that were not necessarily in the form of committees and so on and so forth. But right from 2008, ATREE has lobbied with the state government here for better implementation of this act. We managed in 2010 to have a seat on the National Forest Rights Act Committee and look at the implementation of the Forest Rights Act across the country to submit a report to the then UPA2 government. There was a review done of the implementation of the Act in Karnataka in 2016. And we contributed also to the national review of the 10 years of the Forest Rights Act that was completed in 2016. So these were again much more policy-oriented pieces, documents, reports that were put out in the hope that some policymakers are listening to what we find in terms of lacunae or constraints in the implementation of the Act. More recently, we have put out an analysis of how the critical wildlife habitat provisions of the Act should be understood and how they are being misunderstood in the context of Maharashtra. We have put out an analysis of how the community forest rights provisions are being implemented in Chhattisgarh. And again, what are some of the lacunae that the government could improve. And so this particular report was used extensively when we were part of the Chhattisgarh State Planning Commission's working group on FRA. So it reaches a point of where, yes, you are part of some State Planning Commission working group, and the group's report also incorporates your findings. But in many cases, we find ourselves stymied beyond this point. We don't really seem to be able to go beyond this point. This is an exception where we were actually able to sit with people from the governor's office in Maharashtra and the tribal department and draft the government order on how communities may do CFR management plans. So the idea was to provide a very simple guideline so that people can even make a 5-page management plan. They don't have to make it very technical. They don't have to make it very complicated, but it should address the basic challenges and issues that they are facing and how they plan to address those challenges. So this is this was an attempt to also preempt the introduction by the Forest Department of very technical, complicated guidelines of how a management plan should look. So this was one example where we actually managed to translate our knowledge into some kind of a change in government policy. We've also produced decision support tools, and I'll just give you one example, which is the tool to estimate the potential area that should come under community forest rights. We have done this for 4 central Indian states. We have also actually attempted this for Karnataka and Telangana, where we have basically used GIS to map the possible areas that will come under CFR rights that may lie outside village boundaries, village revenue boundaries, but should normally, given the experience from Maharashtra, should normally come within the CFR claims of the village. And this is just an approximate estimate in order to alert policymakers how far they need to go before they can declare that CFR rights have been recognized and everything is done, and we are kind of, we are done with the implementation of the Act. So we came up with estimates which then tell us that in Chhattisgarh, Madhya Pradesh, Jharkhand, and Maharashtra, the potential area that should come under community forest rights is somewhere between 78 and 90% of the recorded forest area. That is the kind of scale on which CFR rights are likely to be claimed if the process is properly followed. And we always say that this is an underestimate because 2 kilometers is not the extent that often people claim more than 2 kilometers into the forest. So this is the estimate that pretty much 90% or 80% of the state forest is going to come under community control if the act is properly implemented. And at least 2 senior foresters from 2 different states have told me that when they read this report, it sent shivers down their spine. And it should, because it is asking us to restructure forest governance in a very radical way. And it also tells us what is the extent of implementation that has happened in different states. So Chhattisgarh and Maharashtra are above 20% in terms of the area that has been recognized as community rights. And Madhya Pradesh is ostensibly 10%, but those are all fake or misdefined rights. And Jharkhand is at 2%. So it's really a long way to go before we come anywhere close to implementing the most important provision of the Forest Rights Act. We have converted this mapping exercise into an open access WebGIS tool where people can actually zoom into any village or take a perspective at a district or a taluka level in terms of what are the areas that have forests, which are the villages that have forests, which are the villages that have forests that is adjacent or outside the village boundary, which is also likely to be claimed under CFR rights. And this tool is even today available, and people have found it useful not only at a sort of a bird's eye view perspective, but also at the micro level. People have found it useful to understand their particular village in terms of how are the boundaries running in the forest landscape, what are the forest department's boundaries in this context, and how will they have to kind of negotiate or claim their particular forest in this whole administrative terrain. But perhaps the fourth and most important form of engagement is the grassroots action and capacity building. And this takes many forms. The first and most obvious form is to sort of assume that we know a little bit more about the FRA implementation, and we will help local communities claim their rights, whether it is individual forest rights or community forest rights, by helping them understand the ins and outs of the act and the forms and the ideas of evidence and so on and so forth, in order to make their claims and lobby with the government to secure their rights. And we've done a fair bit of that. It can also be in the form of collaborating with communities. Then once they get the rights, and this is particularly true of community forest rights, once they get the rights, how are they going to actually exercise those rights for improving livelihoods, for managing the forest? And this is in some ways the biggest challenge in front of us as the CFR recognition scales up to 5,000 villages in Maharashtra, 4,000 villages in Chhattisgarh, maybe only a few hundred villages in Karnataka, but hopefully expanding a little bit more, at least in the southern Karnataka belt, and eventually Madhya Pradesh, Jharkhand, and so on. There's also work that we can do in terms of building capacities of other grassroots groups, rather than saying that we will work directly with the village or with the Soliya Abhivriddhi Sangha or the communities from different parts of those villages. Building capacities of other groups to do FRA implementation and post rights forest management. And finally, building long-term capacities for decentralized and democratic forest governance. So it's not just about me sitting down and helping a villager fill a claim form. That is still, in a sense, a form of welfare. It's a form of service delivery. What the government should have been doing, what the Patwari should have been doing, or somebody else should have been doing, I am doing in their place because they are either incapable, not interested, not been given the orders, and so on and so forth. So that's the first one, which is helping communities fill those forms, lobby with the government, get those titles one way or the other. But if we have to have a lasting impact, we have to do the last, which is the building of long-term capacity in the community to do this work themselves, whether it is sharing with the neighboring village how to claim the right, or whether it is about coming up with ideas for management. Andre ನಾವು ಜನರ ಜೊತೆಲಿ ಕೂತ್ಕೊಂಡು ಫಾರ್ಮ್ ತುಂಬಿಸೋದು, ಫಾರ್ಮ್ ಅನ್ನ ಫಾರೆಸ್ಟ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಹತ್ರ ತಗೊಂಡು ಹೋಗೋದು, ಸರ್ಕಾರ ಹತ್ರ ಹೋಗಿ ಕೊಡಿಸಿ ಅಂತ ಮಾತಾಡೋದು, ಒತ್ತಾಯ ಮಾಡೋದು, ಅದು ಮಾಡಬಹುದು. ಆದ್ರೆ ಎಷ್ಟು ಸಲ ಮಾಡಬಹುದು, ಎಷ್ಟು ಹಳ್ಳಿಗಳಿಗೆ ಅದನ್ನು ಮಾಡಬಹುದು, ಎಷ್ಟು ಸಮಯ ಅದನ್ನು ಮಾಡಬಹುದು? ಕೊನೆಗೆ ನಾವು ಹಳ್ಳಿಗಳಲ್ಲೇ ಅವರದು ಒಂದು ಸಶಕ್ತೀಕರಣ ಆಗ್ಬೇಕು. ಜನ ಅಲ್ಲಿಂದ ನಿಂತ್ಕೊಳ್ಬೇಕು, ನಾವೇ ಇದನ್ನ ಮಾಡ್ತೀವಿ, ನಮಗೆ ಗೊತ್ತಾಗಿದೆ, ನಾವು ಮಾಡ್ತೀವಿ, ಇನ್ನು ಮುಂದೆ ನೀವು ಬರ್ಬೇಕಾಗಿಲ್ಲ. So the real success of ATREE's venture, हमारी जो कामना है वो ये है कि अंत में एट्री की जरूरत ना पड़े। एट्री की जरूरत ना पड़े कि हम तो पहले लोगों के साथ बैठ के फॉर्म भर रहे थे, अंत में लोग कह रहे हैं कि हम सब जान गए हैं, आप निकल जाइए, कोई बात नहीं, हम जो है इस प्रक्रिया को आगे बढ़ाएंगे, भला वो अधिकार लेने का काम हो या फिर अधिकार मिलने के बाद जंगलों का प्रबंधन करने का काम हो, हम खुद करेंगे, आपकी अभी कोई जरूरत नहीं, जब हमें जरूरत पड़ेगी तो हम आपको बुलाएंगे, किसी विशेष काम के लिए बुलाएंगे। इस दृष्टि से हमको देखना है, वी हैव टू फोकस इन द लॉन्ग रन, बिकॉज द कंट्री इज ह्यूज, द प्रॉब्लम इज मैसिव, एंड द आइडिया ऑफ स्केलिंग अप through government action, that government will somehow go from 1 village to 10 villages and 10 villages to 100 and 500, 5,000 villages may happen, but it will happen on paper. The government will implement at some point CFR rights recognition in mission mode. And in mission mode, we know what happens. Stuff happens in mission mode on paper and rights get distributed. Many times villages don't even know they have received those rights. And they certainly have no idea what to do after that. So the scaling up has to happen laterally, horizontally at the grassroots level. And our biggest task is going to be, while we work at all these levels, while we do our applied research, our lobbying with policymakers, our feeding knowledge into policy circles and so on and so forth, providing tools, this is going to be the biggest task. And what we are here to actually celebrate and present in front of you is the work primarily done at the grassroots by ATREE's teams across 3 different states, starting, of course, in Karnataka, and then Chhattisgarh and Madhya Pradesh, in terms of grassroots action and capacity building. So that's the reason why we are here today. Thank you all for coming, and I'll hand over to the next presenter.